briefly introduce myself for anyone else who's listening in. My name is Ashley Edwards, and I am an associate real estate broker and a certified probate real estate specialist. and my focus in real estate now is more so on the probate, estate, and legacy planning side versus the sales side of real estate. So I went from selling real estate to now helping families preserve their real estate through AAA probate resources. And so with that, I help people protect their wealth, again, preserve their assets, and ultimately create lasting legacies for their families, for future generations. And so I like to say this work for me is very personal. It's not just about business for me, it's about building something that will actually last, a legacy. My journey here actually started with a come to Jesus moment that I had. And in that moment, I had witnessed something happen to someone else in their family. And when I saw that, I literally told myself, Ash, you need to get your together, because I realized that if I didn't do something, that what happened to them could very easily be me or my family if I didn't do something about it. And I was so convicted because despite having been in real estate for over a decade at this point, I was shocked and again convicted by how much I didn't know about estate and legacy planning. And so I literally in that moment became determined to learn everything that I could about protecting my loved ones and building a legacy. And that drive is what then led to the creation of AAA Probate Resources, which is actually named after my daughters and myself, Ashley, Adrian, and Addison, because I wanted to create something that would give them a path to financial wellness and freedom. And so to expand that effort, I created a YouTube channel called Getting Our Shit Together. SHIT is actually an acronym, and it stands for Securing Heirs Property, Investments, and the Generational Transfer of Wealth. And so for me, it's not just a channel, it's not just content, it's a movement. It's my way of inviting others on the journey with me of legacy building. And so through AAA Probate Resources and through Getting Our Shit Together, I basically aim to share insights as to like what I've gained along the way with others. And so I ask you and anyone else who's listening in, if you find any value in what you learned tonight, if you, would join the movement, join the mission, join the community of legacy builders, so that we can continue doing this work and ultimately assisting other families in creating generational wealth for their families. And so with no further ado, I'd like to introduce my friend, my colleague, Miss Whitney Knox Lee. Whitney, she is an expert in estate planning. She's the founder of Wills for the People, and she's basically going to be taking a deeper dive into the legalities around estate planning and the importance of your power of attorney documents. And so, Whitney, if you can introduce yourself and tell us more about the work that you do.
Yeah, thanks, Ashley. So yes, my name is Whitney Knox Lee. I am a estate planning attorney, meaning I help folks get their affairs in order. And my focus is on working with Black and Brown families, first-time estate planners, and other folks that are in that middle income, middle asset range. So my firm is Wills for the People, like Ashley said. We launched in May of this year. So we are still relatively new, although I've been practicing law for 11 years now. And yeah, just really love working directly with my community. And so that's what I really focus on. And yeah, I'll pass it back to you, Ashley.
All righty. So just to kind of go over what we'll be talking about today, of course, we'll discuss why we're even here, what estate and legacy planning is, why it matters, how you can plan for aging and disability, how to communicate your preferences or your wishes with your loved ones, how to anticipate certain scenarios, and then the benefits of these documents, the benefits of your financial and healthcare power of attorney, and the types of decisions that you can make with those documents. And so, again, estate planning for me, it can really just be, it can really be summed up in one word, and that's planning. Without it, even the best of intentions can really fall short of protecting and preserving what matters most to you and what in the legacy that you want to leave for your family. I like to quote Benjamin Franklin. He says, if you fail to plan, you're planning to fail. That quote, it resonates so deeply when it comes to estate and legacy planning because proper preparation is essential in order to avoid risk, in order to ensure smooth transitions after a loved one passes away, and ultimately to secure your family's future. So, what is estate and legacy planning? There are similarities between the two, but there are also some key differences between the two. And I believe understanding those differences will help give you a better view as to where you are in the process. So, estate planning involves having proper legal documents in place. It's about making a clear plan for what happens with your money, what happens with your property, and what happens with your personal wishes after you're gone. And so it also is designed to make sure that decisions about your health and your finances are handled the way that you want. If you can't speak for yourself, whether you can't speak for yourself due to death or you can't speak for yourself due to some form of incapacity. So think about estate planning as like the practical side. It's about creating a plan that's legally solid to protect you and your family. Now, legacy planning, on the other hand, goes beyond the money. It goes beyond all the legal stuff. It's about the values, the lessons, the traditions, those things that you want to pass down to your family. So while estate planning focuses on what you're leaving behind, legacy planning is about why you're leaving it and the impact that you want to have on future generations. So as you can see, the differences here. Estate planning is more so legal documents like your wills, your trust, power of attorney documents, which power of attorney, of course, is what this workshop focuses on. It's like the nuts and bolts of protecting your assets and making sure that they're passed down the way that you want. Whereas legacy planning is more personal. It's about sharing, your family's history, or your family stories, rather, the values of your family, the lessons that you've learned, maybe. So it's designed to be that blueprint for your family to follow, not just financially, but in how they live and how they grow as a family. And so when you combine estate and legacy planning, you're protecting not only what you built, um, or you're not only protecting what you built, but you're also making sure that your family knows the meaning and the value behind what you've built, if that makes sense. Okay. So why does it matter? It matters for several different reasons. One, to avoid risk. When you do not have planning in place, the risks are significant. Families lose wealth due to legal battles, high taxes, lengthy probate processes, and a lack of preparation. It often leads to emotional stress, confusion, um, disrupting family dynamics, conflicts. The list goes on. And it also matters because you want to, of course, secure your family's future. Proper planning, it changes everything. I like to look at it as a literal game changer, and I like to call it your route to wealth. That's technically what it is, because death isn't inevitable. It's a fact of life. It's a harsh reality, but it's a fact of life, and everything that lives must one day die. So planning protects you and it protects your family when that happens, not if it happens, but when it happens. And more importantly, it allows your family to focus on grieving and healing through the grief and moving forward rather than getting all caught up in the unnecessary challenges that can arise because you failed to plan. And so, with power of attorney specifically, this is one of the components of your estate plan. It's a legal document that grants someone that you trust the authority to make decisions on your behalf. So, this could include financial matters, it can be healthcare decisions, or it could be both. But it's particularly crucial in situations where you're unable to act or speak for yourself due to illness, injury, or some other unexpected circumstance. that's not death. Okay. So it's more like I think it's called a living document. I think that's what the term that a lot of attorneys use, because it's designed to safeguard your assets um, while you're alive, whereas your other estate planning documents, like your will and your trust, are designed to safeguard your assets after your death. Okay. And so again, today's focus is specifically on this power of attorney document, and to truly understand the role that those documents play in your overall estate and legacy plan. It's essential to um, hear from an attorney or an expert. And so that's why I'm so happy to have Whitney here with us today. She's gonna discuss the importance of it, of course, the uses, how you can use a power of attorney, and how those power of attorney documents fit into your broader estate planning strategy.
Okay. So thanks, Ashley. So yes, we are going to jump right into what the power of attorney is all about. Again, my name is Whitney Knox Lee. I'm an attorney, an educator. I'm a mother. This picture is of my two children, Everett and Royce, and my husband, Jeffrey. And then I also have a podcast called Impostrix Podcast, that validates professionals of color who are navigating imposter experiences and racial toxicity in their careers. So I am quite busy during my week, my life. I'm going to talk a little bit about why we plan, what are the dangers of not planning, what are the types of powers of attorneys here in Georgia, and then the limitations to powers of attorneys. So I wanted to start with some quick facts, because I think this helps to put it in perspective about the importance of planning for incapacity. So approximately 70% of people over the age of 65 will need caregivers at some point. So if we live to be 65 years old, we will probably need a caregiver, whether that's part-time, full-time, whether that's a paid caregiver or a family member. We will need help taking care of ourselves. The top demographic needing caregivers are people over the age of 50, followed by special needs children. I think this is interesting because a lot of times we're thinking about powers of attorney for our parents, our aging parents, and other elderly folks. But it's really important that we consider powers of attorneys for ourselves as well. Because the power of attorney, it allows you to identify a person who will make decisions in case you cannot care for yourself and in case you cannot make decisions for yourself. And we all know that that can happen literally at any moment. It could happen at any age, through any number of ways, like a car accident, like a planned surgery that went wrong, like a medical emergency or a heart attack. We do not have to be 65 and we do not have to be 50 to need help caring for ourselves. Um, and then lastly, I think it's just really important for people to recognize that most people will die of chronic health issues, and frailty. I think, at least for myself, I've always thought about like when I die, it's going to be like a sudden thing. I'm just going to drop dead or I'm going to be in an accident and it's going to be sudden. But the fact of the matter is that most of us do not die suddenly. If we're dying of a chronic health condition and if we're dying of frailty, what this means is that towards the end of our life, it's very likely that we are going to be utilizing support, whether that's community support and community caregivers, or again, caregivers in our family. So just as we think about ourselves aging, and as we think about the end of our own lives, it's really important to plan for the times where we are not able to care for ourselves. And the power of attorney documents are one way to do that. So the reasons why we plan, Ashley talked about some of them, but autonomy. So in the state of Georgia and around the country, are we are the rulers of our own body. So we make decisions for ourselves as long as we are over 18, as long as we are bound to have capacity for ourselves. At the point where we can't make decisions for ourselves, nobody else can make decisions for us legally unless we have authorized them to do so. But when we have already lost capacity, we don't have the requisite intellectual functioning, or maybe we're just not even awake because we're in a coma. We don't have the ability to be able to authorize somebody else to make the decisions. So, because people can't just make decisions for other people legally, legal decisions, we have to give that authority to someone else. And we can only give that authority when we are in our right mind. Okay. Planning is great for saving time and money because if we don't plan, we risk our family having to go to court to get a guardianship or a conservatorship. Those take time and they also can be costly, particularly if it is a contested situation where there is somebody else in the family who contests a chosen guardian or conservator. Another reason to plan is to make sure that our wishes are known, to make sure that our loved ones and the people that are caring for us know what we want to happen in the event that we get ill, in the event that we become terminally ill, in the event that we fall into a coma, in the event that we are in an accident, or even just at the end of our lives, when we are dying of being frail. We want to make sure that the people who are supporting us know exactly what we would want to happen. And then lastly, so that we can keep control over our care. If we don't have a plan, then somebody else is going to make a plan for us. So at the end of the day, the question is, do I want to decide how I'm cared for and what happens in my life, or do I want somebody else to decide? So what happens if I don't plan? This is a huge, huge source of frustration and grief and anger and turmoil in families. Is the result of not planning our affairs and even powers of attorney. We often think of powers of attorney as the kind of like light estate planning documents because they're less expensive and they really, when we're talking about estate planning, a lot of times we focus on wills and trusts. But powers of attorney are critical because, as Ashley said, these documents are in effect as long as we are living. And so these are the documents that are going to help people take care of us while we are still on this earth. So if we do not plan, then our family is having to figure out how to take care of our business because we have not given them the authority to do so. So that is going to mean, like I said, them figuring out filing guardianship and conservatorship proceedings in probate court. That may mean figuring out who to pay bills to, how to pay bills, how to access bank accounts, whether or not there's money in bank accounts. They will need to budget. They will need to do a number of tasks to care for you that they don't actually have authority to do. So they will have to find ways to kind of get in to these accounts, whether or not they actually have legal guardianship or conservatorship. The cost of not planning is quite high. And this is just as far as the cost of hiring an attorney to assist when somebody needs to get guardianship or conservatorship. I looked up one law firm's fees. These were the middle of the fee ranges. Column one is the fee for uncontested guardianships and conservatorships. So it was around $4,500. And that's uncontested. And then column two is the fee for contested conservatorships and guardianships. It was around 7,500. And remember that this is an expense. So when somebody needs a guardianship or a conservatorship, usually something is happening like right now, today, that the family or the loved ones need to step in to help manage. When I've represented people, family members in guardianship actions, sometimes it might be somebody has a psychiatric illness and they are in an episode, and the family members need access to medical records, for example, or they need access to bank accounts to be able to pay bills. the one of our the mothers of my client was missing. She had disappeared in a psychotic episode. And we were trying to track her down. And we needed to, because she wasn't there to be able to answer our questions, um, her daughter, who was my client, needed to be able to access things like her finances. She was trying to access her phone records so that they could see if they could run a trace on the phone to see where the mother was. So when you have to hire an attorney to help with a guardianship or a conservatorship, you need that money like now. So if you don't got $4,500 in your bank account now to be able to spend on an attorney, that might be an issue. But also, it's going to take time. This process can take time. So, what is happening to your loved one who needs help caring for themselves while we are waiting on court? Okay, so that's one of the big risks that we run when we do not plan. Okay, so what is a power of attorney document? In Georgia, we have three. We have the financial power of attorney, we have the healthcare or medical power of attorney, and then we have the psychiatric power of attorney. And each of these documents handles a different kind of area of our lives. But they all are similar in that they allow you to identify someone else who will make decisions on your behalf in the event that you cannot make decisions for yourself. And that person who you are selecting to help you with your decision making is known as the agent, or also known as the attorney in fact. So when you're hearing that language, that is what you're talking about. You're talking about the person who is able to make decisions for somebody else on their behalf and has been given that power through a power of attorney document. So the first one is the healthcare power of attorney. This document is broken up into several parts, and the more significant parts within the document are the treatment preferences, the disposition of the body, your life support preferences, and then your end of life preferences. So as far as treatment preferences, I'm talking about things like if you have specific cultural or religious beliefs that make you not want to receive certain types of treatment. For example, I recently worked with somebody who did not want to use blood products. She did not want blood products used. She was, I can't remember the religion, but it was a part of her religious practice. She also did not want animal skin grafts. And so we wrote that in. So the power of attorney allows you to say if there are treatments that you absolutely do not want. The disposition of body, that is talking about if you want your body donated after you pass away for medical study, or if you want organ donation. I'm going to skip life support for a second and go straight to end of life preferences. This is talking about where do you want to be when you pass away? Do you want to age at home, or do you want to be in a hospice or in a nursing home, or are you okay passing away in a hospital? So you can put those types of preferences within your healthcare power of attorney form. And when you're working with an attorney, based on what you say, we will help you decide which life support options are going to give you the best chance of your end of life preferences becoming true. So the life support options are often the most confusing part of this particular document. You have three choices as far as what kind, if any, of life support that you want. You can choose to have full life support. That means all the tubes, all the ventilators, CPR, nutrition by tube, fluids by tube. You can choose to allow your natural death to occur. So you don't want any of it. You just want pain medications to keep you comfortable. And you can choose a hybrid of those. So maybe you're someone who does not want to be on a ventilator, but you do want nutrition and fluids by tube. You can choose to have only some of those options that would typically be covered under life support. You're also deciding in which circumstances do you want this level of life support. in a coma. So if you are in a permanent state of unconsciousness, you are not expected to come out of this state of unconsciousness. You are in a vegetated state. Which type of life support do you want? And if you have an incurable and non-treatable illness that will result in your death in a relatively short period of time, what level of life support do you want? So these two decisions are often where attorneys will spend the most amount of time with their clients because it can be a hard decision to make. I was talking earlier about your end of life preferences. I'll say if you are somebody that really wants to pass away at home in their own bed, then we advise not having life support because the machines and tools that are necessary to provide life support are at a hospital. Also, things like my understanding is if you need a ventilator, you also are probably going to need CPR. So you can't really split those two decisions. If you want one, you're probably going to get both. Okay. So that's the major decision that's being made in the healthcare power of attorney. The financial power of attorney, on the other hand, is dealing with assets and your finances. The agent, the person that you have identified to help or to make decisions on your behalf, is going to be able to, well, you will decide which of these powers and more you authorize them to have. You can decide that you want them to have all the powers, or you can decide that you only want somebody to be able to access your bank accounts. And so we've got many things up here in this slide, and there's even more powers in the actual document itself, but it includes real estate transactions, it includes access to bank accounts and paying bills, stock and bond, emails, and electronic communication, communicating with insurance providers and setting up insurance or ending, terminating insurance, government benefits, rights of survivorship, disclaiming property, Medicaid planning, creating trusts, changing beneficiary designations, and more. And then the psychiatric power of attorney is new in Georgia. I believe it came into effect in 2022, maybe earlier. But similar to the healthcare power of attorney, it is allowing people to make decisions on your behalf. Excuse me, if you are somebody that has a psychiatric illness and you experience a period of decompensation or psychosis, you can plan for that by choosing somebody to be your agent who can make decisions for you when you are in this period of distress. With the regular healthcare power of attorney, there's several things that your agent cannot do. They cannot involuntarily commit you into a rehabilitation center or a psych ward. They cannot authorize a lobotomy or other types of invasive brain procedures like a lobotomy. They also cannot force you to take medication. Okay, so the psychiatric power of attorney deals more specifically with some of the issues that people who are experiencing psychiatric illnesses need support with. How do I choose who my agent should be? This is a common question, and I always say we need to think about this very practically because, again, this is the whole reason why we're planning is because we want it to be as easy as possible for me, the principal, the person who is making the power of attorney, to be cared for. So your agent should be somebody who is nearby or easily accessible, easy to reach. They should be somebody that you can trust with these types of decisions. If it's a financial power of attorney, they should be somebody who manages their money well. Somebody who you don't think will run away with your money because they're going to have access to it. This should be somebody that you know well. These people should not be new friends or strangers. Does this person answer the phone when you call? Are they reliable? Do they live in a city or state that has a branch of the bank that you bank at? Or if it's a medical power of attorney and you have a chronic medical illness, is the person that you want to be your agent, are they around to be able to like meet you at the hospital and speak with your doctors? Do they have time in their schedule to be able to take phone calls from doctors on a whim? All of these decisions are decisions that you need to make when deciding who your agent should be. And then how does the agent actually use your power of attorney? So once you've created that document, whichever of the three or all three, you will provide them to either your agents themselves or to your medical providers and to your financial institutions for them to have on file, or you can do both. In order for the agent to actually be able to make the decisions that you need them to make, the authority that they are speaking to, so we'll use a doctor's office, for example, they need to know that they're your agent. They're going to have to prove it. They're going to have to show the paperwork that is authorizing you to make decisions on their behalf. So with power of attorney documents, you can make photocopies of the documents. You can make electronic copies of the documents. Some people choose to give the institutions the documents as soon as they've created them. Other people choose to wait until there's an emergency and then tell a loved one where these documents are. Yeah. The major limitations with power of attorney documents, with financial power of attorney documents, not all banks will accept them. And that's really their prerogative, unfortunately. Another limitation is that power of attorney documents are only in effect while you are living. So once you pass away, your agent no longer has power. They no longer have the authority to access your medical records or your bank account. After you pass away, your executor or your estate administrator takes over to handle all of your business. So although you're choosing an agent, that person only has authority while you are living. Other limitations, sometimes we want to make changes to our powers of attorney, and it's important that we actually just do a new document instead of writing on the document, because that can void it altogether. So earlier I talked about the cost of not planning. You'll see on this column, it's uncontested. So paying an attorney for an uncontested guardianship or conservatorship here in Georgia, approximately $4,500. Paying an attorney for a contested guardianship or conservatorship, approximately $7,500. Typically, 4 to 500 is pretty average for paying an attorney to do power of attorney documents. My fee is $415 to do 2 of the power of attorney documents. And then for part 2 of this workshop, we are offering the healthcare power of attorney and the financial power of attorney for $199. So you can see, I mean, even on this graph, just how much you can save by planning ahead. And spending a matter of a few $100s as opposed to several $1,000s and a lot of time. So that is the end of my part of the presentation, and we have time now for some questions. If there are any, I do want to say join us for part 2, which is January 11th from 10 a.m. to 12. It is in person, and the location is to be determined, but it'll be in the Atlanta area. Again, the fee for that is $199. What you will receive when you go to that event is a healthcare power of attorney and a financial power of attorney with the notary that you'll need. I've also put our contact information up on the screen.